Hi, this is attorney Brian Parker. As a follow-up to the deposition techniques I created in a previous video about the rule of 5, I'm going to show you sort of a three-part video of a deponent that is being deposed without any instructions or proper help. You'll see the results of that. Then you'll see the second part of the video where I will instruct her on the rule of 5. And then the third part of the video will be her deposition after she receives the instructions. Notice the difference in length between the first part, where she first is deposed without instruction, and the last part of the video where she has received the instruction. The time difference is quite interesting because with the rule of 5 deposition techniques, they are designed to protect your client, to protect you, and to protect their story. A deposition is not the place for your story. I know that sounds kind of backward, but the minute the other side hears your story, they'll have 3 stories of their own and 3 witnesses saying yours is nonsense. So you always have to tell the truth. The rule of 5 is designed to eliminate words. Words are oxygen for seasoned litigation attorneys. You do not want to be, or you do not want your client in front of a veteran litigation attorney, because eventually you'll get broken down. So if you can get out of there in an hour or less, the chances of you saying the wrong thing are very minimal. The rule of 5 empowers people to eliminate the anxiety. Anxiety and emotion make us go like this, and you do not want that from a deponent you are seeking to protect. So the rule of 5 techniques are on display. How they work, you'll see me train the deponent and the benefits of that training. Along with this video, there will be my show notes from my previous deposition protection techniques using the rule of 5. It's actually also a life hack. Those show notes will be attached to this video. And you know what? I'll take that video and sort of bundle it for you. So when you go to the membership website, you can have a cool bundle to protect yourself or your client from the ravages of a forceful, veteran, sneaky, tricky attorney that does this for a living. This could be your only time in front of in the deposition arena. So you've got to protect yourself and your client with the rule of 5. I hope this works for you. Thank you. What is your name?
My name is Debbie Detter.
And where do you live, Miss Detter?
I live in Brooklyn, New York.
Do you have an address?
My address is 555 Fifth Ave, Brooklyn, New York.
Okay, and how long have you lived there? And who do you live there with?
I live by myself. I've lived there about 4 years.
Do you own or rent?
I own.
And are you familiar with the lawsuit in this case?
I am.
How are you familiar with it?
I have received numerous letters in the mail. I don't know what they're referring to, but I believe that my deceased husband and his children have stolen my identity.
How were you served the lawsuit?
I had someone come knock on my door and ask me to sign for papers.
And why did you sign for the papers?
I had no idea what they were.
Okay, so you didn't read them? You just signed for something you didn't read?
I did.
Okay. Were you familiar with the plaintiff in this case, Jefferson Capital, before they sued you?
I was not.
You'd never received any letters from them?
No, I haven't.
Because you just said earlier you'd received letters.
Of the lawsuit.
Okay, so you were familiar with Jefferson Capital Systems?
No,
All right. Do you owe the debt?
I don't believe I do. My identity was stolen.
Okay. How will you prove that you don't owe the debt?
You can compare my signatures to my driver's license. They don't match the papers that I've been shown.
Okay. Was there a contract attached to the lawsuit?
No, there wasn't.
Then what is the signature you want me to compare to?
If you call Jeff Corp and ask them for proof that I signed it, it can't match my signature. I never signed it.
Have you looked at the proof accompanying the lawsuit?
They haven't given me any proof.
Nothing was attached to the lawsuit?
No,
Is it your debt?
it is not my debt.
How is it your name is on the lawsuit and the debt?
Well, if my name was attached to the debt, the lawsuit would automatically go to me, but I never signed up for this debt. My identity was stolen.
In this case, you filed a counter affidavit. Did you sign this?
Yes, I did.
And who wrote the counter affidavit?
My attorney.
So you didn't write the counter affidavit.
I did not.
Did you have any input into the counter affidavit, the information?
I did.
What was your input?
My input was that I never borrowed that money. I didn't take out those loans, and it was identity theft by my deceased husband and his children.
Okay, is any of the affidavit you signed and you had your attorney write false?
No.
Okay, this is the instructions for the rule of 5. Let me see your hand. Hold up your hand in the air. All right? You're not swearing to anything. Just spread your fingers. All right. Now look at your hands. See your thumb? Wiggle your thumb. No or yes. Now this, I think it's called an index, perhaps. Do not guess. Last 3, 5 words or less. Let's do it again. No or yes. Do not guess. 5 words or less. Got it?
No or yes. Do not guess. 5 words or less.
So when you answer any question that's no or yes, you answer only no or yes. You do not volunteer any information. The purpose of you being deposed is for the bad guy, the other side, to get as much of your story out of you so that they can use it against you at trial, or have 3 witnesses to say you're not telling the truth because they know your story. So while we always must tell the truth, we tell as small a version of the truth as possible. A deposition is not a good time to tell your story. Is that clear?
Okay.
No, the answer would be yes.
Yes.
No or yes, do not guess, 5 words or less, right?
Okay.
Nope, the answer would be
Yes.
So
Yes.
take it, I'm going to show me your hand. Wiggle your thumb. What do you say?
No or yes. Do not guess. 5 words or less.
Got it? Nope, the answer is
Yes.
And no if you don't.
Yes.
We do not nod our heads or shake our heads because the court reporter can't put that
Okay.
down. Okay?
So no or yes.
Yeah.
Do not guess.
Yeah.
5 words or less.
Okay, got it?
Yes.
All right. So you were sued, is that correct?
Yes.
And who sued you?
Jeff Corp.
Okay. And how do you know that?
I was served
Good. And how were you served?
by mail.
By mail. Okay. And you drove here today?
Yes.
What kind of car?
BMW.
BMW. Okay. And how many miles you had on that vehicle?
I'm not sure.
Very good. Normally what people do is hold up our hand, wiggle our finger. We do not guess. It's no or yes. Do not guess. 5 words or less. Got it?
5 words or less. So I'm not sure is okay.
It's always okay if you're not sure. You don't say that even if you know. You have to tell the truth, right? So you did a good job. You're not sure how many miles. What color is the car?
Green.
And why did you buy that vehicle?
I like green BMWs.
Okay, so I liked it would have been a better response because 5 words or less. So the part of 5 words or less, let's hold up our hand again. See the 5 words or less? We are allowed to formulate as small an answer as possible. So you said, I like green BMWs. Perhaps you say, I like BMWs. And so what I want you to do is not answer quickly. Take a 5-second delay before you answer a question. Is that clear?
Yes.
And one of the reasons we say and tell people to do that is because, believe it or not, the longer you take to answer a question, the quicker you will be out of that room. Because you do not want to be in front of a bad guy litigator for very long. So it sounds counterintuitive or counterproductive to say, if I take my time, I will be out of there quicker. But the thing is, the answer that you come to will be so small.
They can't ask you more questions.
Right. Words are oxygen to attorneys. So the more words you say, the longer they live. So one of the points of the rule of 5 is to provide as little oxygen as possible so you can get out of there.
Okay.
Got it?
Yes.
Okay. So you said you received the lawsuit. How did you get the lawsuit?
In the mail.
In the mail. So again, let's hold up our hand. No or yes. Do not guess. 5 words or less. Your answer was in the mail. And you didn't listen to my 5-second instruction. What's a quicker way to say in the mail?
Mail.
Got it. I know why you're uncomfortable saying that, because that's not how we communicate. We're an accommodating species, correct?
Yes.
You're not here to be accommodating. The more accommodating you are, the greater chance your lawsuit's going to be dismissed with your own words. You understand?
Yes.
Okay? So we all have this nice human accommodating spirit inside us. If we're going down the road, someone asks us for directions, we're going to take the time and help people out. Not here, we're not. They are only here for one reason, that is to kill your case or defense. And you provide them with that oxygen and the way to do that with words, and you kill your case at trial. Or worse yet, they'll take a transcript of your deposition, attach it to a summary disposition, and kill your case with your own words. Do you want that?
No.
That's good. Okay. So how did you say you received the lawsuit?
Mail.
And what does that mean?
It arrived at my door.
It arrived at your door is 5 words. On my door.
On my door.
Now, I know again you're thinking, who talks like that to another person? You do. In the small amount of time and the amount of time you're in front of a bad guy, it's up to you. You talk like, you ready? Like a robot. No, yes, do not guess, 5 words or less. We don't care what he thinks about you. We care about what he hears from you or doesn't hear from you. Is that correct?
Yes.
Good. You were sued on a debt. Is that correct?
Yes.
How do you know that?
By the lawsuit papers.
Okay, so a better answer is 5 words or less. Read it.
I read it.
Read it.
Read it.
So you do not want to give anything. So you take your 5 seconds, right? And then you answer. Let's do it one more time. Hold up your hand. Tell me exactly what it means.
Yes, no.
No or yes.
No or yes.
Yeah.
Do not guess.
Yep.
5 words or less.
Correct. And you notice they sound like they rhyme, correct?
Yes.
That's why we go no or yes. Do not guess. 5 words or less. You got that?
Yes.
Yes. Okay, good. Did you happen to read the lawsuit?
Yes.
And what made you read the lawsuit?
Addressed to me.
Curious would be the best answer. It's one word.
Curious. Okay.
One of the reasons you respond like that, because it drives the other side crazy. And a lot of attorneys are lazy and they have a book of questions. So if you screw up their book and don't answer correctly, it screws them up and you'll have them out of here sooner. But if they don't understand your answers, they can't follow up with the question. Or if they really want an answer, they have to keep asking you questions. At which point your attorney can say, objection, you keep asking the same question, and you're familiar with it on TV, asked and answered.
Yes.
So it shuts them down. Now they're stuck not going to their next section of questions because they weren't able to get you the way they think they were going to get you. The reason why I developed the rule of 5 is because it is empowering. A deponent comes in nervous and scared. By the time I'm done with them, they realize they can have fun with the other attorney. Fun means less anxiety, better answers, better preparation. You take your 5 seconds, and you're not answering in a way that kills your case. Is that clear?
Yes.
Okay. Show me the rule of 5 again.
No or yes. Do not guess. 5 words or less.
Okay, good. So did you read the lawsuit?
Yes.
What was in it?
Debts.
Debts. Are they your debts?
No.
How do you know?
Didn't sign.
I don't understand. Not mine would be the best.
Not mine.
Because he can't say, well, prove it's not yours. I'm not here
Prove
to
it's
prove.
mine.
Yeah. Yeah. Well, no.
No.
Remember, we're not accommodating him. So what do you read in the lawsuit? What was in there?
Debts.
Debts? Are they your debts?
No.
How do you know?
Not mine.
Okay. But my client, I represent the bad guy debtor here, the debt collector, says that you do owe them. How would you argue with that?
Never signed.
Okay. Have you looked at the proof accompanying the lawsuit?
No.
Why not?
I never signed.
You never signed? Okay. Well, I don't understand. It has your address, and we've tracked your IP address to the person that signed up for the debt, and it's your home, your Xfinity account. How do you reckon with that?
Identity theft?
Identity theft. Do you have any proof that it's identity theft?
No.
Did you sign any documents?
No.
No. So how do you know any of this is false?
I never signed.
Part 3, questioning the opponent after the rule of 5 instruction. Good afternoon.
Good afternoon.
What is your name?
Debbie Detter.
And where do you live?
Brooklyn.
Brooklyn where?
Brooklyn. New York.
New York. Okay. And how long have you lived in Brooklyn?
4 years.
And do you live in a house?
Yes.
Do you rent?
Own.
You own. And have you always owned your own home in Brooklyn, New York?
Yes.
Where did you live before that?
Brooklyn.
Okay. Did you receive a lawsuit in this case?
Yes.
And when did you receive it?
I'm not sure.
And did you receive it in the mail?
In the mail.
In the mail. Okay. And what did the lawsuit say?
I owed money.
Okay. Did it say to whom you owed money?
Yes.
And was there a name of the person who you owed money to?
Jeff Corp.
Jeff Corp. Okay. And is it a debt that you owe?
No.
How do you know?
Never signed.
What do you mean, ma'am, you never signed?
It's not mine.
Can you prove you don't owe the debt?
No.
So that you do owe the debt?
No.
How do you know you don't owe the debt?
I never signed.
Have you looked at the proof accompanying the lawsuit?
No.
So how do you know it's not your debt?
I never signed.
Did you file an affidavit in this case?
Yes.
And did you sign this affidavit?
Yes.
Did you write the affidavit?
No.
So who wrote the affidavit?
My attorney.
Is any of the affidavit you wrote false?
No.
Thank you.